Well, when we were here last time,
but
Mr.
hold
Helping,
on.
you did
What?
not
Hold on,
identify what
Mr.
you
View.
wanted.
When I say hold on, everybody in the courtroom stops talking. Do you understand that?
I do.
You have. Don't you dare interrupt me, Mr. Hubling.
Oh, I wouldn't dream it.
25 CR 42785. Present before the court is Mr. Hawthorne, represented by Mr. Hubling, and we have Mr. View from the prosecutor's office. We are here today for a conference in advance of our jury trial to begin to set to begin here in a few weeks. Mr. View, what's our status?
Your Honor, my understanding is Mr. Helbling has met with Mr. Hawthorne and discussed the status of the case, and Mr. Hawthorne's prepared to proceed to trial on January the 22nd, 23rd, the dates we have scheduled. Previously, we were here before the court on November the 25th of 2025. At that time, the state had made an offer to the defendant to plead guilty to count 2, the possession of deadly weapon while under detention, for a minimum consecutive sentence of 2 years mandatory to 3 years. During meetings with the court suggested a resolution to an alternative count of as a felony 3 for an agreed 24 months without the additional Reagan-Tokes tail. My understanding is that Mr. Hawthorne is rejecting the resolution of the case and wants to have a trial.
Mr. Helbling, what's our status?
Your Honor, with regard to the, did he say that F3?
Yeah, he said that F3.
No, the F2 is what you're charged with. The secondary offer was an F3 or F2? It was an F3.
Right.
I think that was
Without the tail.
hold on a minute. I think that was my suggestion to
Right.
resolving the case, which was
Right.
an F3, 24 months consecutive.
And my notes are, my indication was I'd be willing to accept it if Mr. Hawthorne was willing, and it sounds like he's not willing.
You understand what they're offering? So they're offering you, instead of one with the Reagan-Tokes on an F2 or F1, they're offering also an F3, which is still 2 years without the tail. Does that make sense?
Still the second.
The second one is an F3, which is not Reagan-Tokes. You know what Reagan-Tokes is, right?
Yes,
Okay. So the 24-month agreed sentence would not have the extra year. Because Reagan-Tokes would be a 2, half of that would be 1, so it would be a 2 to 3 sentence.
See, okay, I understand all that.
Okay.
If y'all not understanding this, I'm already up on the Reagan-Tokes.
I know.
So if I agree with this 2 years consecutive, I had to do the 3 years Reagan-Tokes and didn't do it, so it would be altogether 5 years that I would have to do. It would be 5 years that it wouldn't be
It
the
can
2
be
years.
it can be up to it. I don't think it's necessarily automatic.
No, it's 3 years. Since I violated my violated with this case, they gave me 3 years.
Let me clarify that for you on the record. Okay, does that make sense?
No,
You're
I'm talking about not what they offering.
Right. Your Honors, you're aware that he's already serving time, and there's a Reagan-Tokes on the time he's serving. The question is, with this, if he agrees to this violation, would that be the tail at 100%, or could it be an increment between that? I think the question is. Do you understand what I'm asking?
I mean,
Talking about on the existing case?
No, on the case he's already been sentenced on.
I'm not sure I understand what you're asking, but also B, the administration of the Reagan-Tokes time is not a judicial function. It is a function of the Ohio Department of
Right.
Rehabilitation and Corrections
Right.
and the executive branch of government. I don't have any say over what they do, so I don't know that there is an answer to the question, at least as I understand it.
So technically, it could have been up to 31. Did they already give you the
They
Reagan-Tokes?
already gave me my Reagan-Tokes 3 years on Reagan-Tokes. Not instead of doing 26, I have to do 31. And then
So you are going to do the 31.
right now with this additional 2, that would be 5 years altogether for this. But if I set this consecutive,
It would be 2 years, not 5.
It
Oh,
would be-
3 plus the 2. I see what you're saying.
exactly.
All right. I think you answered it, Your Honor.
All right, defense ready for trial?
Yes.
All right, so Mr. Hawthorne, the reason that I put all of these discussions on the record is I've been doing this for a while now, and if we go to trial, and if you are found not guilty, obviously nothing happens to you. If we go to trial and you're found guilty, sometimes what happens is I get a letter 6 months, a year later, something like that, that says, hey, I didn't know about some plea offer, or I didn't understand it. That's why we put all these discussions on the record. You have the right to have this case tried. If you don't want to plead to anything, that's fine. Nobody's trying to coerce you or influence you. All I want to make sure is, because I used to do this once upon a time. I used to be on the public defender's list. I used to represent people in the prison. So I just want to make sure that all of these offers are communicated to you so that you have a full knowledge of what you're choosing between go to trial or take the months or years or whatever it is. You understand all of that?
Yes, sir.
Okay, do you have any questions of me?
No.
All right, so we are set for trial. I am going to order, Mr. Hawthorne, that for the purposes of the trial, that you be shackled at your feet. So you'll notice that the table in front of you has a modesty panel. So if you scoot up underneath that panel, jury's not going to see that you have on leg shackles. But I am, as long as you behave yourself during the trial, going to allow your hands to be free so that the jury does not see that you're in handcuffs. Also, you have the right to be dressed in civilian clothing if you want to. Since you're being transported by the prison will not transport you in civilian clothing. So you have to make arrangements with Mr. Helbling to get civilian clothing here for the trial, and then you change out once you're here. So if you don't have people on the outside that can get you clothes, let Mr. Helbling know what your size is. He'll go to the Goodwill and buy you something. Or if you have clothes that you want to wear, that part doesn't matter to me. The jury's already going to hear that you're in prison, obviously, because it's part of the case. But if you want to sit there in civilian clothing rather than a jumpsuit, you just need to make sure that we have arrangements to get that clothing here on the day of trial. Okay?
So, Your Honor, the only other issue is that when we were last here, I know the case was continued because defense counsel had indicated there was some additional information he was attempting to get. I have not received any further defense, I haven't received any defense reciprocal discovery. Make sure we don't have any other evidentiary issues that defense counsel has any evidence or defense risk. I would ask that be sent to the state in compliance with the previous state's request for reciprocal discovery, just because the timing of this case in relation to some other trials that I have in January. So I don't want us to end up kind of jammed up.
Yeah, my only question is, when we were in chambers, we did talk about the video, and I've shown him the video. But as I mentioned in chambers, there was some mention of a little bit earlier footage on the video that I don't have. And they mentioned it, I believe, in one of the police reports or one of the investigation reports. It's about maybe a couple minutes before it. And I would just ask if they could maybe check out and get me a supplement.
I provided you everything that I have, Mr. Helbling. You have what I have. You have the recording that I have. If there were other things you were seeking from the Department of Corrections, seems like you've had an opportunity to seek those things.
Your Honor, for the record, what I'd like to request is additional footage. And if that means to get a new trial date on this thing so I can look at it. But it's mentioned in this that we have seen, and I'd like to see it. And it has some issues in it as to where the weapon might have come from. And I think it's germane to the case. You know.
So are we ready for trial or not?
Your Honor, I'm going to say no, we're not, because I want that extra footage.
Okay.
I want that extra footage, and I know that counsel has given me what he has.
Well, when we were here last
but
time,
on
Mr.
the-
Helbling,
Hold on.
you did
What?
not
Hold on,
identify what
Mr.
you
View.
wanted.
When I say hold on, everybody in the courtroom stops talking. Do you understand that?
I do.
All right. Let's hold on so that we're not talking over each other. Mr. View has represented to the court and to you that you have everything that he has. That satisfies his obligation under both reciprocal discovery and Brady to give you what you have. Don't you dare interrupt me, Mr. Helbling.
Oh, I wouldn't dream it.
Once you get all of the discovery, you have the ability, if you want to inquire of the Department of Rehabilitation and Corrections to any additional footage that they might have that might not be in the possession of the police, or it might not be in possession of the prosecutor's office. If you want additional time to do that, we talked about this back in November. It was my understanding that since no continuance was requested and we were ready to go to trial, I'm in no hurry to try this case, except we do have a try-by date, which If you file a motion for continuance, I'm perfectly willing to grant you the request for continuance if you want additional time to research the case.
Yes, Your Honor, thank you. I would say that the video that was given to me, it's grayed out in the time period that I'd like to see. So it's sort of there, but you can't see it. It's blurred out. It's grayed out. So I just want it so I can view it. And if I need to contact the prison, I will do so, sir.
Mr. View?
I mean, if we were here on November the 25th of last month and he had asked for that, then we could have made arrangements to contact the Department of Corrections. But Mr. Helbling didn't identify what this other information was that he wanted at that time. So I have provided what's been provided to me by the Department of Corrections. I'm not aware of any other video. If it was not saved as part of the investigation, some larger time frame, then it's not going to exist. But if defense counsel wants to investigate that further, he can file another request for a continuance. This is the second trial date we've had. And the court's willing to grant it, then I guess that's where we're at.
From the video I've seen, Judge, it was saved. It's just blurred out for whatever reason. I don't know if it's their program or what.
All right, well, let's do this. If you want to subpoena the folks from the Department of Rehabilitation and Corrections to provide you with this information, we can have them here on this date, because it is my guess, having done a number of these cases before, that whatever video may have existed at the time, if it has not been properly preserved, it's probably been written over already, but I don't know the answer to that. So if you want to make some inquiries with the Department of Rehabilitation and Corrections, I do believe that Ms. Idle has a contact at the Department of Rehabilitation and Corrections for this specific type of request.
I will
But
do so.
it's not the state's job to do your homework for you, but also
Wouldn't ask it.
I want to make sure that everybody has the opportunity to fully investigate the case. Anything else?
No, Your Honor.
All right. And I apologize to counsel for raising my voice. You did hit on one of my hot button issues, which is talking over me, but I do apologize because I should have been a little more statesmanlike about it.
Thank you, Your Honor. No
All right,
worries.
we're in recess. Representing himself, we have standby counsel, Mr. Helbling, and we have Mr. View from the prosecutor's office. We are here today for a plea hearing. It's my understanding that since the last time we were here, there have been some plea negotiations. I understand that there is an offer from the state to reduce the charge to a F3, which would be an agreed 24-month sentence with no judicial release. Is that accurately stated, Mr. View?
I mean, in a sense, yes. I mean, the offer was made to me from the defense and was accepted by the state. That's why we scheduled for a plea today. But yes, if Mr. Haythorne is prepared to go forward today, we are prepared to resolve the case today.
That wasn't part of it, but that's what he put in. You can discuss it.
So, Mr. Haythorne, it's my understanding that even though you're representing yourself because of the logistical problems and you communicating directly with Mr. View, that you sought the assistance of Mr. Helbling to try to communicate a resolution to the case. Is that right?
Yes, sir.
So where are we at on this?
Your Honor, may I speak
Sure.
for the record?
Is that okay with you, Mr. Haythorne?
Yes, sir.
Mr. Haythorne gave me the ability to negotiate the F3 as we discussed. I just need to put this on the record. The offer was for a 2-year deal on the F3 of the attempt. I received word back via email from Mr. View that was accepted. Nothing in either of our emails discussed judicial release. I've spoken to Mr. View, and he'll correct me if I'm wrong on this. He took that to mean no judicial release. I did not mean that, but it's in the plea form. So it's there, but that was not part of my negotiation or understanding, just for the record.
Okay. So something got left out. Mr. View assumed that if he is going to reduce the charge to an F3 and agree to 24 months, that it was going to be with no judicial release. Maybe that wasn't an assumption that was shared on your part, but it is my understanding as we sit here today, Mr. View, the state is only willing to reduce it for a 24-month with no judicial release, right?
That's correct, Judge.
Is that acceptable to you, Mr. Haythorne, or not?
Just so the record is clear, on April the 8th, I responded back to Mr. John, I appreciate your offer and your efforts on Mr. Haythorne's behalf. I have discussed your client's offer with OSHP, ODRC staff, and within my office. I just want to confirm that this is an agreed sentence with no judicial release and that it will be served consecutive to Mr. Haythorne's current sentence. Your email does not reference a consecutive sentence. I will not accept concurrent sentences. Please confirm that your client's offer is a consecutive 24-month sentence. Mr. Helbling responded to me then on April the 8th, indicating it is for a consecutive sentence of 24 months. So I did clarify to him in my email that it was for no judicial release.
All right. A lot of people are telling me stuff that I don't care about. All I care about is where we are today. And as we sit here today, F3, 24 months consecutive to the time that he's doing, no judicial release. Is that right, Mr. Review?
That is correct, Judge.
Mr. Haythorne, do you understand the terms of that?
Yes, sir.
Is that what you want to do or not?
Yes, sir.
He's serving a sentence for aggravated robbery. I mean, he'll be placed on mandatory PRC.
Yeah, I mean, you're already going to be on PRC anyway because of your underlying offense, but if something happens that your other offense got thrown out and this was the only offense that you were serving time on, then you would be subject to an optional period of post-release control of up to 2 years. Do you understand that? All right.
Yes, sir.